Hi there, I'm Savannah Mexto with Manor Law Group, welcoming you to another Webinar Wednesday with esteemed estate planning and elder law attorney, Bob Manor. If you have a child with a disability or special needs, this week's Webinar Wednesday is especially for you. Today, you'll learn the unique planning considerations and tools that are available to ensure your child will always be cared for, even after you're gone. Peace of mind is possible with the right planning. Learn more on today's webinar. But before I pass the mic to Bob, I'd like to cover a few housekeeping details. First, note that even though Bob is an attorney, today's webinar will not give specific legal advice. If you have a question about your unique situation, please contact us after the webinar. If you have a general question during today's presentation, please use the question box. We will save time to review questions during the webinar. If we don't get to your question, we'll contact you after the presentation. And of course, note that today's presentation will be recorded and the replay will be sent out tomorrow so that you can share it with your family, your friends, or anyone who you think could benefit from hearing this information. Now, why should you listen to what the folks at Manor Law Group have to say? We are a nationally recognized and respected elder law and estate planning firm. All three of our attorneys are accredited by the Veterans Administration to assist veterans with claims and appeals. Our managing attorney, Bob Manor, is nationally board certified as an elder law attorney by the National Elder Law Foundation. He's one of only 19 attorneys in Michigan to achieve this designation. Bob is also a leader among elder law attorneys in Michigan. He is currently chair-elect of the State Bar of Michigan Elder Law and Disability Rights Section and past president of the National Academy of Elder Law Attorneys, Michigan chapter. And Manor Law Group has been honored by readers of our local paper as the best or favorite law firm for the last 8 years in a row. Without further ado, I'd like to welcome attorney Bob Manor.
Hi, folks. We're going to get right into this here. So let's see. Let's talk about why this is important. So we're going to refer to the term that a lot of you probably have heard before called special needs trust. We're going to talk about alternatives to special needs trust, but why is this even important in the first place? And the answer is that if you have certain types of benefits as a result of some inability to work full-time, then depending on the type of benefit, and we're going to go through an example of some of the types of benefits that are out there. Some of the programs, if you get an inheritance, you'll lose those benefits, or for some of them, any inheritance over about $2,000, you could potentially lose the benefits. Now, there's always ways to work around that. So if it's too late and you've already got the inheritance, there's definitely things that we can still do. But the idea is to say, how can we set this up so that we can get in front of it so that we don't even temporarily lose benefits, or that we don't have to go through more difficult, more challenging options that require more scrutiny and still not disinherit our children that have special needs or disabilities. So we're going to talk about the different types of trusts that we can use for that purpose. And sometimes people have a will, and sometimes they have a trust. Sometimes they have both, or usually if you have a trust, you have both. But you can deal with this even in a will. So when I use the term special needs trust, it doesn't mean that I would probably recommend it, but you don't necessarily need to have a trust. You can even have a special needs trust set up through a will. So mom and dad don't have a trust, they have a will, but within their will, they have a special needs trust set up for their special needs child. All right, so we're going to talk about that. We're going to talk about if the money's coming from a third party like mom or dad through an inheritance, through grandma and grandpa through an inheritance, or if the money's already in the name of the special needs child. So, or special needs individual, doesn't have to be a child. So maybe a lawsuit settlement, or some other reason why that they have assets. I had a situation recently where the person had been on SSI, so a form of disability benefits through Social Security, and they got married, and because their spouse was employed and had assets and all of these things, they lost that particular benefit because they look at the spouse's assets in that particular benefit. But then they got divorced. But as part of the divorce settlement, they had assets from that marriage. And so then the question is, well, can we get back on SSI? And the answer was, well, yes, but we have to now do a special needs trust for the assets that you accumulated as part of this divorce settlement. And then we're going to talk about some alternatives to the trust, which are really some really interesting options. So let's get right into that. So this is the first step that we want to look at here is what public benefits are out there. So you see a picture of a gentleman up in the corner here. That's my buddy Kevin Urbach, and a fantastic special needs attorney, primarily based out of California. He is actually licensed in Michigan also, but primarily based out of California. And he did a presentation the other day, and so I borrowed this slide from his presentation, which I think is a real good summary of the some of the programs that are out there. So one of the things that we want to look at is it a needs-based program, meaning that we have to look at assets and income? Is it an entitlement-based program, meaning that it's not subject to, it doesn't matter how much money you have in your bank account? That's an entitlement program typically, and other benefit programs. So the needs-based programs that we're typically going to be looking at, and this is what we're going to be most concerned about when we talk about the need for a special needs trust or alternatives to the special needs trust, and that's going to be the supplemental security income, or SSI. Sometimes we just say we're getting disability through Social Security. Well, there's different types of disability through Social Security. So the one that is needs-based is supplemental security income. And this is typically where you have not paid into the Social Security system for a sufficient period of time. In other words, typically, in order for you to get this, we typically prefer to get the SSDI, which is the Social Security Disability Insurance, over the supplemental security income. But in order to qualify for Social Security Disability Insurance, you have to have paid into it. You've had the job where you were paying into Social Security for 10 years. They define it as 40 quarters. Well, 40 quarters, for fourth grade math, what are 40 quarters? Well, 40 quarters are 10, so 10 years. So if you paid into Social Security for 10 years, then we likely can qualify for Social Security Disability Insurance. Now, sometimes we haven't paid in enough in order to get more than what we would have otherwise gotten under supplemental security income, and you can get both. They're dual eligible for both supplemental security and Social Security Disability. And the idea there is that we qualify both as a needs-based, and we paid in for 10 years or more, but what we paid in was not sufficient to meet at least the minimum that we would have gotten paid under supplemental security. So what are the other needs-based programs? Well, we got Medicaid. Typically, these are going to be things for sometimes it's going to be your medical insurance, medical needs. Sometimes it's going to be long-term care. Sometimes it's going to be home care, those types of things, and the in-home care Medicaid benefit. Entitlement programs, we already talked about Social Security Disability Insurance. There's the childhood disabled beneficiary. So the disabled child of someone who's qualified for Social Security, a parent that's qualified for Social Security, and Medicare. Okay, so the nice thing about Medicare is if you've received SSDI, Social Security Disability Insurance, for 2 years, then you get eligible for Medicare even before your 65th birthday, and that can make a big difference on making sure that we're getting the medical needs care covered without having to pay an exorbitant amount for insurance. And then there's other benefits like housing, veterans benefits, and food stamps. And so we got to consider all of those when we're looking at this from the standpoint of planning. So what's the purpose? Well, we've discussed this. It's the idea of, twofold. On one fold, the most important thing is to make sure that whatever assets that we have are going to still allow us to, or that we would get in the future, meaning through an inheritance or something like that, would allow us to still qualify for those medical benefits and for the disability benefits. Sometimes that can cost, I mentioned Kevin a minute ago, and he was saying if you actually do the math, even for the relatively small amount that you get through SSI, if you add that up over 40 years, 60 years, it's a whole lot of money. It's in the millions. And so the idea is that that can make a big difference. So we don't want to necessarily have to spend all of the money that we have and then not have any money for extras, not have any money for a cell phone, not have any money for being able to go on vacation every once in a while, not having any money to, to go beyond the very bare minimum basics just because this person has special needs. And so it's very, very important. Occasionally we'll hear of people come into the office and they'll tell us that they went to an attorney or they went to their neighbor or whatever, but they got the advice of just disinherit your special needs child. I've heard people say that that information or that advice came from an attorney many, many times, and that's a real shame. So I get it if you're not an attorney and you don't realize that there's options to this, but the fact that attorneys are saying this, that's a real shame. That's a real shame that people are saying you have to disinherit your special needs child and not, give the money to the other child and hope that they're going to use the money for the special needs child. No, that's a really bad idea. Even if you trust your other child, you say, oh no, they love each other. They're going to take care, the other child is going to take care of the special needs child. Okay, but what happens when they die? What happens if they die? What happens if they get sick? What happens if they get in a lawsuit? What happens if they get divorced? What happens if they, file bankruptcy? What happens if they lose their house to foreclosure? We don't want to just give the money to the other child and say, well, I'm sure they'll take care of their brother or sister. And this is so much better because it's very accepted. It's accepted through, all throughout the country, and very well established and accepted by the Social Security Administration and other government agencies. And so, we've talked about what the purpose is and what happens if you don't have protections here. So this is real important, and I'm using sort of non-legal terms here. There is many lawyers, when they refer to these, they're going to refer to them by the code sections that are allowed, where these forms are allowed or these trusts are allowed. But I like to use these terms because they're a little easier to understand and kind of distinguish between the difference. So a third-party special needs trust is where the money never went into the individual's name. Okay, so it was set up prior to the death where they were going to get inheritance. So this is something that mom and dad do, grandpa and grandma do, a court might do through a settlement. There are a number of options of how this is set up, but the money never went into the individual's name. It's going to be set up in advance so that when the money is going to go to for the benefits of that individual, the trust is already set up. Okay, so the trust is set up in advance, knowing that mom and dad are eventually going to die. They want to leave some money for their special needs child. So rather than having the money distributed to that special needs child, it goes into this trust that was previously set up. This is by far the most flexible type of these trusts. There's several things that are more important about that, and why we would always prefer to do this over the other types. First of all, it's not a payback trust. So the other two types of trusts are what they call payback trusts. And what that means is that whatever money the government put into it through Medicaid or Medicare or other benefits, disability benefits, if there's money left over when the individual dies, they got to pay it back out of the first party trust or the pooled trust. They got to pay back whatever was spent by the government. And usually that's going to be more than what's left in the trust, right? So a lot of times all of the money left in the trust at the death of the individual is going to end up going to the state. Whereas a third party trust is not that case. If there's money left over in the third party trust set up for the individual with special needs, then that goes to wherever you want it to go. So mom and dad say, all right, I've got two kids, one of them has special needs. We're going to divide it 50-50. 50% is going to go into the special needs trust for the individual with special needs, but they have a short life expectancy, or maybe they don't, but they just happen to die younger. Well, that money then, when that individual with special needs dies, that you can say, well, that's going to go to their brother or their sister, or if their brother or sister died, it can go to the nieces and nephews, or it can go to a charity, or it can go, wherever you want it to go. You can specify. It doesn't just go to the government. Whereas with the first party and pooled trust, it does. That's where the payback is. It goes to the government to the extent that the government spent money. And so that's very important. So we always want to do that. So a lot of times we have very well-intentioned grandpa and grandma, and they say, oh, well, we really want to make sure that Charlie's taken care of, and so we're going to leave money aside for Charlie because Charlie has autism or whatever it is. And so they list Charlie in their will or their trust, or they list Charlie as a beneficiary. Then Charlie receives the money directly. It knocks him off of his benefit. So they were very well-intentioned, but we got a problem. Now, that doesn't mean it knocks him off his benefits, because we could use the first party or the pooled trust at that point, but it would have been so much better had we done better planning and set up a third party trust so that the money is there, but if the individual, we're calling him Charlie, has special needs and he receives these benefits, if he didn't end up spending that money, then the money will stay with the family or go wherever else that you want it to go, okay? The idea of a first party trust is you set that up once the money is in their name. So we do it for lawsuit settlement. We do it if they didn't set up a third party trust and they inherited money. Anytime the money is already in their name and we want to be able to continue those benefits or get benefits for the first time, we would use a first party trust. And that is much more highly scrutinized by the Social Security Administration. They really go through it, and it kind of varies from year to year as to how aggressive they are, but it is much more scrutinized by the Social Security Administration than the third-party trust, and it has the payback provisions. Pooled trust is a really nice option because the thing about a first-party trust is you really have to follow all the rules of it. So there's rules on what you can spend money on, what you can't, documenting it, making sure that you're only doing the right things. And it's quite a bit of regulation. And so with a first party trust, I usually recommend that in addition that you either have a professional trustee, which is expensive, or at least if you have a family member as trustee of the first party trust, that you have an attorney sort of on call that can assist you through the years, over the years, to make sure that you stay in compliance on the first party trust. That's one of the things that my friend Kevin Urbach does. He helps families with that type of a thing to give them advice, and I have other friends that do that also. And then the third one is the pooled trust. And the idea of the pooled trust is really unique because we don't have to hire a professional trustee. We don't have to worry about a family member following all the regulations because it goes into a pooled trust, but it's a segregated account that would, we know that money is to go to this particular individual with special needs. And so, but it's managed professionally, but it's not nearly as expensive as hiring your own private professional because it's a pooled trust. So it's done where they, group the money together with multiple, many people that have contributed money. The money is segregated for them, of course, in the event that they pass away and there's still money left. It is a payback trust. Okay. So what about alternatives to special needs trust? Well, this is really interesting, these ABLE accounts, ABLE accounts. And the ABLE accounts are really interesting. It's one of the things that I chuckle about with ABLE accounts is that I think a lot of the politicians thought that, there's a lot of people that don't really like lawyers, and they're like, well, I don't like that when somebody has special needs that the family has to hire a lawyer, which I get. If we could make it all simpler, that'd be great. But, that was, I think, one of the motivations of the politicians is these would make it so that we don't need special needs trust. Well, clearly that's not the case. In fact, lawyers have attached on to these ABLE accounts and said, these are fantastic, let's use these ABLE accounts, but we use it in conjunction with the special needs trust. So if it's a small amount of money, we can just use the ABLE account and we don't need a special needs trust if it's a small amount of money. But one of the things that's neat about the ABLE accounts is we can take the money out of the special needs trust to fund the ABLE account. So what is an ABLE account? An ABLE account is set up by individual states, but you can pick any of them. So you can be a resident of Michigan and use the North Carolina ABLE account. You can be a resident of Florida and use the Michigan ABLE account. And so I've showed you on this map as of probably last year which states have ABLE accounts. It's the states in blue that have the ABLE accounts. And again, it doesn't really matter. It's just that's the state that organizes the ABLE account and is kind of holding the money, or the entity which the state has designated is holding the money. The nice thing about ABLE accounts is that they're often much more flexible about what you can spend on. There's things that you can pay for out of an ABLE account that you can't pay for out of a special needs account. And it's much more easy to keep track of. A lot of them have sort of safety valves in there, so you don't have to have as much knowledge and regulation and making sure that you're following all the rules with an ABLE account. You still have to follow the rules, but they're not as stringent, and they're a lot easier to comply with. And so what many lawyers are doing is they're saying, okay, every year we're going to take money out of the special needs trust, fund it to the ABLE account, and then we spend the money out of the ABLE account, and then we put more money in next year. The other thing we like about ABLE accounts is there's actually a tax deduction of putting money in the ABLE account. Now, there's a couple of restrictions. You can't have an ABLE account unless your disability was documented prior to age 26. Okay, so this is really important. So if you became disabled at age 30, age 29, or whatever, or maybe you were had special needs before that, but it was never documented, then we're going to have to try to document it or not do the ABLE. So the ABLE account only can use for those folks that we have documented special needs prior to age 26. You can only contribute $15,000 per year to it. It has a maximum amount. It's a little over 100,000, or maybe it's 140,000, something I don't remember. But there's a maximum amount that the account can't be more than this amount. But the idea of the ABLE account, I had somebody come to me a while back and they said, well, we want to maximize the ABLE account and then we'll start funding the special needs account and a trust. And I said, well, no. The ABLE account is to spend. We want to spend that money, and we want to continue to contribute more money to the ABLE account because we get a tax deduction for contributing to the ABLE account, because it's easier to spend, all of these other things. So if we're going to contribute money to the ABLE account, we also want to spend that money in the ABLE account. Okay, it's our sort of first choice to spend that money first, and then we put more money in next year. So we can put 15,000 now. What if two people contribute 15,000 to the same account? So grandma and mom both contribute 15. Well, that's a no. We can't do that. We can only contribute. It's not per person. It's only a total of 15,000 per year that can be contributed to any one individual's ABLE account. But it's a really nifty kind of a thing that it makes it more flexible, and lawyers that do special needs trusts love them. And so I think it was, I chuckle because some of the politicians thought that they were getting rid of the need for lawyers, and what they did is they gave us another resource, which is great and fantastic, and makes it life a little bit better for folks with special needs. So it is something that you're probably going to want to get advice on. You can call us, schedule an appointment with us, or other lawyers that focus their practice on special needs, but to get an idea of which ABLE account you should join, because just because you're in Michigan doesn't mean you should join the Michigan ABLE account. Okay, we got to look at what you're using it for, what the needs are, and things like that. So that's the ABLE accounts. How to set one up? Well, I highly recommend that you go to a lawyer to do this. This is I would highly recommend any trust that you do, that you go to an experienced and well-qualified lawyer to do that, such as us, for example. But the idea is, a lot of times I'll see people come in with these trusts that they downloaded from the internet or whatever else, and usually they're really bad and not very good. But definitely you would never want to try to do that with a special needs trust. There's way too much scrutiny on a special needs trust from the Social Security Administration. So I don't think you can even download. I would hope that there's no place where you can download a form for a special needs trust like some people do for a revocable trust. If there is, it's certainly malpractice or practicing law without a license, because you should never just use a form for a special needs trust. You want to have it really needs to be precise and specific to their needs, and you need to have a well-qualified, experienced, up-to-date lawyer to do that, such as us. But the bottom line is the rules with regard to special needs trust are frequently in flux and change, and so this is not optional to use a lawyer when you need a special needs, whether it's third party, first party, whatever. You want to have an experienced lawyer. So there's some things that you can do where you go to a general practice lawyer that does pretty much anything that comes in the door. When it comes to special needs trusts, or you have a special needs child or something like that, you really want to have somebody that that has experience in this and a good amount of experience in this, like our law firm, but it's not something you'd want to go to a general practitioner for because there's just too much involved in that and too much at risk if it goes wrong. So, all right, so we're gonna, Savannah's gonna come on here and she's gonna tell you how to get some of your questions answered. So hopefully I made you think about a few things and it raised some questions. That's fantastic. We love questions. We'd be happy to help you with those questions. So you can schedule a time to talk to us or just call us, and Savannah is going to come on and give you those instructions.
Thanks, Bob, and thanks everyone for joining us today. As Bob mentioned, there are some easy ways for you to get in touch with our team, whether you would like to schedule an appointment or maybe you just have some questions. Either way, we're here to help. You can always give us a call at 1-800-990-6030. Again, that's 1-800-990-6030. Give us a call, ask questions. We'll ask you a few questions, and then we can decide what's best from there. Also, if you're attending today, watching the live webinar, there's a link in the chat that will take you to a Calendly page, which is just a calendar where you'll choose a day and a time where you'd like to have a member of our team call you. If you're not watching live today, you can always visit manorlawgroup.com, www.manorlawgroup.com, and you can contact us there as well. There's a button that says contact us. You can reach out that way too. So either way, we're happy to get in touch with you. And of course, we would love to see you again next week. Have a great day.